The next matter to come before the court this morning is State of Ohio versus Timothy Myers. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you would like to reserve that time, if you let me know, I'm keeping the clock this morning. The court's read the briefs and we're ready to see when you are.
Thank you, Your Honor. I would like to reserve 3 minutes. May it please the court. My name is Heaven DiMartino. I'm here on behalf of the State of Ohio, the appellant in this matter. We are asking that this court reverse the trial court's decision granting the defendant's motion to suppress. The journal entry in this case is a bit inconsistent in that the court found that there was probable cause based on the detective's statements in the affidavit. But then the court found that it was unlikely that the marijuana would be present, essentially finding that the information was stale and or that there was no nexus between the defendant's home and the undercover buys that took place. Then the court found that there was no good faith exception, essentially finding that the officer should have known that this was a deficient warrant, but this was after saying that the detective's statements actually did provide probable cause. So I'm not sure how to get around those two findings. One, that the detective's statements are enough for probable cause, and then a finding that this officer should have known better, so there's no good faith exception. With regard to the first issue with whether or not there was information that the drugs were likely to be present, the affidavit shows that the officer had an ongoing investigation from January until June regarding Mr. Myers possibly trafficking in marijuana. It refers to one confidential informant making an undercover drug buy, and then it refers to a fourth buy scheduled with the same CI to take place at the defendant's residence, which is the Aloha Street residence, on May 28th, and the warrant was issued on June 3rd. So those two dates are sufficiently close in time, which isn't even the necessary standard, but clearly May 28th and June 3rd would be close enough in time for an officer to believe that that evidence would still be there. The officer also put in the affidavit that it is common practice for drug dealers to keep records, money, contraband, etc. in their home. The affidavit said that this was Mr. Myers' home, again noting that there was this ongoing investigation and the most recent drug buy being scheduled for May 28th. It is true that the warrant does not go into detail about the other two buys. It's also true that there is no additional information about that May 28th buy. But for purposes of whether or not there was probable cause for the warrant, looking at whether or not it's likely that the drugs would still be in the residence, there certainly is enough in the warrant to show that there was a nexus between the home and Mr. Myers, that the officer had been involved in an ongoing investigation, was using the same confidential informant, had a buy scheduled at this defendant's home. Therefore, the information was not stale and there was a sufficient nexus. And the state would argue that there absolutely was good faith on the part of the detective who testified to 22 years experience working in undercover buys. There's nothing in the record to support the court's finding that just because this officer had 22 years of experience, he should have somehow done a better job, when on page 4 of the journal entry, the court found the fact that there was sufficient statements by the same detective to support a finding of probable cause. And based on those...
The appellee cites the case of the State of Ohio versus Ruffin. Could you speak briefly as to why that finding is not applicable in this case?
In State of Ohio versus Ruffin, the court basically found that the 8-day, the drug buy that had occurred 8 days prior there was not a sufficient nexus there. And here we would argue that this case is distinguishable on that basis because there was a nexus here. There was an affidavit noting ongoing investigation between the detective and this defendant since January, a buy that was scheduled to take place on the 28th. The warrant was issued on the 3rd of the very next month. So that takes it out of the parameters of Ruffin. I believe in Ruffin the court found that there was a good faith exception anyway, so didn't perhaps go into the depth that maybe would be needed to here. But again, based on the inconsistencies in that journal entry, I don't believe that the court could find that there was probable cause and then say that that officer didn't have a good faith exception if there was any error. And based on that, the state would ask that this court reverse.
Thank you, Your Honors. May it please the court. My name is Benjamin Sorber. I represent the appellee in this matter, Mr. Timothy Myers. There's two questions before this court today. The first is, was there substantial basis for the magistrate issuing the search warrant to conclude that there was probable cause based on the four corners of that search warrant? The second question is whether the good faith exception applies to save this warrant if it was deficient. So addressing that first question, based on the four corners of this affidavit, there was not probable cause. The affidavit only talks about one controlled buy that took place between the police officer's confidential informant and the place that was being searched. Now, under Segrove v. United States, the court held that there must be a substantial nexus between the place being searched and what the officer is searching for. Now, in this case, that just does not exist. The one buy that we have, we don't know where it took place, we don't know when it took place. We're talking about an investigation that lasted roughly 6 months, if not more, according to the officer's affidavit. Because we don't know where that controlled buy took place, there's nothing to tie the evidence and the information that the officer had to Mr. Myers' home. Now, the case State v. Ruffin that we cited in our brief goes into detail a little bit more about this. In Ruffin, there was two controlled buys that took place. One happened 8 days prior. The police watched the defendant in that case leave his home, and the buy took place someplace else. Based upon those facts, this court stated that that case presents a close call. Now, that was a case where in the affidavit for the search warrant, the affiant listed where the controlled buys took place, when the controlled buys took place, and who participated in them. In this affidavit, we don't have any of that information. The state says that there must have been a buy recently because the officer says there was a fourth buy scheduled to take place at Mr. Myers' home, but they don't say what the outcome of that is. So we have, based on the four corners of this affidavit, we don't know if there was any contraband at that home. We don't know why that buy didn't take place. And we can't surmise that. We can't guess what the officer meant to say, because information that's known by the officers that's not put in the affidavit and relayed to the issuing magistrate can't be considered for a finding of probable cause. So based upon those facts, there was not a substantial basis for this warrant to have been granted. Now, moving on to the good faith exception. Now, this is an exception that the United States Supreme Court carved out in United States v. Leon. This is an exception that saves the state's evidence from the exclusionary rule. The exclusionary rule was created by the court as a deterrent for either misconduct on the part of the state or negligence on the part of the officers. And that's exactly why the exclusionary rule applies to a case like this. Because here we have an affidavit that's supposed to set forth probable cause, that's supposed to tie contraband that the police are looking for to Mr. Myers' home. But that affidavit doesn't tie the contraband to Mr. Myers' home. So because of that, the exclusionary rule would not apply in this case, or would apply in this case, but the good faith exception would not. The exclusionary rule is supposed to be a deterrent for conduct like this. So based upon that, we would ask that the court would affirm the finding of the trial court. Thank you.
Just briefly, that the state would argue that the fact that the affidavit does not discuss the outcome of the May 28th buy or whether or not it occurred is irrelevant to the issue of whether the information was stale or whether there was a nexus. Because the court found that the information was that there was not likely that the marijuana was going to be present at the home. But if the officer believed 5 days before the warrant was issued that there was going to be a buy based on information between the defendant and the confidential informant, that the buy was going to happen at the defendant's home, then that would support the finding that the police officer based the affidavit on his belief that their contraband would be in that home at that time. The issue of whether or not there was marijuana there is really not dispositive of whether the information in the affidavit supported probable cause when you're looking specifically at this issue of nexus or whether the information was stale. And again, the good faith exception set forth in Leon is to deter police misconduct. There was no police misconduct in this affidavit. The officer put in the information that he believed was sufficient to obtain a search warrant. The information is in there. There's no evidence that the officer lied, misled the judge, failed to include information on purpose. This is just a situation where if this court finds that there should have been more information perhaps on the other buys to establish whether the first, second, and third buy also occurred at Aloha, something to that nature, that does not lead to the conclusion that this detective with 22 years experience engaged in misconduct that would warrant a finding that he did not act in good faith. And again, that final buy was scheduled to be at Mr. Myers' home on Aloha in the course of a 6-month investigation involving a confidential informant who had made at least 4 separate interactions with the defendant. Based on that, we would ask the court to reverse the trial court's decision and find that there was sufficient probable cause for this warrant and that the officer acted in good faith.
Thank you both for your presentations this morning. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted on our website and the Supreme Court website. Thank you.